right, I now turn your attention to the deed of trust. Did you have an opportunity to take a look at that? The deed of trust dated May 31st, 2006. It's the yellow piece of paper on top that I hand wrote
that
for you.
one, yeah, okay.
So I forgot my deed of trust.
I did.
Thank you. On page 2, I'd like to turn your attention to page 2, paragraph H.
Right.
On that page, it gives the definitions of different terms that are in this document. And one of the terms on that page, I believe, is loan. Is that correct?
Yes, under H it states the word loan shall mean, comma, the debt evidenced by the note.
Okay, so in this document, it is giving a different definition of the word loan than what typically we would know the word loan to mean.
Well, I'd have to look up the definition of loan, but if you're saying that the word loan shall mean that you have incurred a debt, then I would have to agree with the deed of trust.
Okay, so the word loan for this document shall mean the debt evidenced by the note.
That's correct.
Okay, so in this situation, the word loan does not mean that I was lent any money by Homecomings?
Objection, Your Honor. It's not exclusive, it's inclusive.
Ms. Quintel, can you rephrase the question, please?
Well, it's very simply stated. It is inclusive because it is in the document. It is the language that Homecomings created for their own document.
It doesn't state it's exclusive or inclusive,
I don't know what that
therefore it's
means.
neither.
Can
You better
you tell me
learn.
what that means?
In other words, it means loan and or maybe yes or no, the actual definitions, layman definitions. It's giving an additional definition. So you just got to be able to have that argument. Because no, you're stating on and for the record that in this case, loan only means that and not anything else.
Okay, all right. So, Your Honor, what I am basically trying to say is that in the document created by the bank, Homecomings Financial Network, Inc., their language for the word loan is given a definition just for that document to only mean that the word loan shall mean the debt evidenced by the note. And therefore, it is not the same definition as given by Black's Law, 6th edition, page something, paragraph whatever, that says that the word loan means a party has been lent a sum of money for a particular purpose.
You know, we'll stipulate that it's just, for the record, we don't need to have that discussion.
Okay, can we move forward?
Sure. So in other words, Mr. McCaffrey, in the note and in the deed of trust, did you find anywhere in either document that ever stated that Homecomings Financial Network, Inc. actually lent me the sum of $448,000?
In those two documents, no. But additional documents that would have to be provided by counsel, I would have to review to see whether or not you did receive $448,000.
But if I received $448,000, it wouldn't have been for a loan, according to these two documents. Is that correct?
You're really painting me into a corner here, but
Yeah, objection.
out of everything
Objection,
that I've
Your Honor.
seen.
She's really leading the witness. She's trying to get him to state on and for the record things that are not necessarily his expert opinion. Move to strike.
Yeah, we'll strike that from the record, and please continue on with further questions.
Okay. At any time, did you have an opportunity to take a look at the chain of title as to what entity may currently be the beneficiary of this promissory note?
There you go.
I was going to get there.
Objection,
I was
Your
hoping
Honor.
he'd get there.
Objection, Your Honor. That presumption's already been laid in the non-judicial foreclosure, and this court doesn't have standing to undo the previous court's ruling.
First of all, I don't know what I'd call it.
Have you entered pleadings to?
Yeah, I have entered a complaint that was filed on March 29th, 2010, disputing the fact that the documents currently entered into this court and into the county recorder's office are fraudulent, forged, and also additional evidence has been submitted of a forensic examination that have been done on those documents to prove evidence of fraud, malfeasance, and perjury has been committed by one or more of the defendants, ens legis, to attempt to get the purported chain of title to which they claim to have the ability to steal my property.
Your Honor, objection. Their failure to rebut the presumptions previous to the foreclosure, they've forsaken the right for their rebuttal.
The presumptions of the court stand unless challenged, and you have not.
We have challenged them.
You
Your
have
Honor.
challenged them.
Absolutely. In
Your
the
Honor,
complaint and
they-
all pleadings, they've been challenged. As soon as the evidence was discovered, it was put
Do we
into the
have
court.
that entered in a pleading?
Absolutely. If you take a look at my most recent
Objection, Your
document
Honor.
filed.
It was not entered before the non-judicial proceeding, so we did capture that presumption, and we stand on that presumption.
Mr. Stewart, there's no way that she could have entered those before you filed your non-judicial foreclosure.
Your Honor, I do not concur. She had several years to file a rebuttal to the court's presumptions.
What say you?
Your Honor, it is my understanding that fraud at any time vitiates everything, and discovery of fraud may not have happened at the time of the fraud. I was not aware of the fraud. I was not even aware at the time that the documents for the notice of
Your Honor,
trustee that fraud had been
plaintiff-
committed. But
Plaintiff has
however,
failed to state a claim inclusive of the elements of fraud.
I have, if you will let me speak, I'd be more than happy to state those claims. I have stated them in my pleading. You have a copy of those claims, and they are that.
Overruled, Mr. Stewart, please continue.
Thank you. Thank you. Since the evidence of fraud vitiates everything, and in my report, I'd like to question Mr. McCaffrey a little further about the chain of title, which would give them the right to
Are you
potentially
going to
foreclose.
continue much longer? The court's time is precious, and this is dragging on.
Okay. So back to the question. Mr. McCaffrey, did you at any time have an opportunity to discover the chain of title as to what entity currently is the beneficiary of the promissory note?
I have.
And what were your findings?
I'd like to point that out to the court. The first document that I reviewed was a corporate assignment of deed of trust, transferring all ownership to BAC Home Loan Servicing. What I found out is that BAC Home Loan Servicing is the master servicer and is not the beneficial interest in this particular pleading, and they are not the beneficial interest in the loan. And therefore, this document that I find that was filed is invalid.
Objection, Your Honor. The county recorder says it's valid, so is McCaffrey countering the county recorder's office?
Objection. I don't believe the county recorder, Helen, whatever her name is,
Purcell.
Purcell?
Helen Purcell has actually viewed this document to have an opinion, and I don't think that he's qualified to voice an opinion on behalf of her.
We have an expert witness here. He's giving us his testimony, and I'm going to let it stand at this point.
Thank you, Your Honor.
The first document that I reviewed has a transfer from MERS, which is Mortgage Electronic Registration System. It was initiated and notarized on February 6, 2010, and recorded in the county recorder's office on, February 6, 2010. It was recorded on February 8, 2010 at 3:31.29 in the afternoon. The second document that I reviewed was also recorded on February 8, 2010 at 3:31.29. In that document was a substitution of the trustee from MERS to Recon Trust. Also done by the same notary on the same date, in the same state and the same county, and also filed with the county recorder's office. Third document that I reviewed was dated and recorded on February 8th, 2010 at 331.29. And that would have been the notice of trustee sale. All three of those documents, in my opinion, I cannot tell you exactly what document was filed at one particular time. And in my opinion, professionally, I would find that a document, meaning all three
Objection,
documents
Your
are
Honor.
filed.
We have the presumption that the bank operated correctly unless they can establish it did not operate correctly. The witness has stated on and for the record that he's not sure. Therefore, our presumption must stand. Be considered that although it was the same second, the documents were recorded in order correctly in the order per every 10th of a second. Therefore, we are correct.
Mr. Stewart,
That's impossible.
that sounds a little fishy to me, and I'm no expert, but I'm gonna allow Bill here to continue, and you're overruled.
In my expert opinion, I find that the chain of title on this has been broken, and the issue of the beneficiary that is foreclosing on Ms. Cantrell is listed as Bank of America. We've uncovered that it's not Bank of America who has standing in this and should not be represented in this court of law, but a different entity. It's a trustee by the name of Bank of New York Mellon, who is actually
Objection,
acting
Your
as the
Honor.
trustee.
Objection. The defense in this matter, we are just strictly defending ourselves. The plaintiff brought this action against us. So if we don't have standing in this matter, we're not considered the real party in interest, that's fine. This case can be dismissed with prejudice.
You're dismissing your own case.
No, I'm the defendant.
Okay, right.
You better have a comeback
You
for
better
that.
have, what do you
Better
got?
have a
I
real
don't even
good
know what
comeback.
you did. What did you just do?
He's trying to get away.
You're trying to dismiss the case in my favor?
Your witness, no, in mine. Your witness said I don't have standing. Okay, you should be suing New York Mellon. You got to come back at them that it was the fraud. It was my fraud that made, because I was coming after you. You're the plaintiff in a defense against our fraud. The plaintiff the defendant refuses to name the indispensable parties because they're hiding it through their acts of fraud so they don't get discovered for their acts of fraud.
Okay. All right. Your Honor, because of the fraud that the defendants have committed jointly or separately in this matter, I was not until recently able to even uncover the fact that New York Mellon is the potential holder of this note. And it's only because of their acts of fraud that kept me from being able to see that. They are the ones that are coming after me. They are the entities that are trying to steal my home. New York Mellon is not. And therefore, we can't dismiss this case unless we dismiss it favorably in my favor, because I am the one that's being harmed by their actions.
Okay, they don't dismiss it in your favor. You're the plaintiff.
Oh.
But there again, the immediate human response of arguing, more huff female than male. The issue being that what happens here is I've again left you an opening. Okay, I did, the bank did the foreclosure. Are they not now trying to fight you on the indispensable party, this Rule 17A, blah, 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 real party in interest, because I'm not the real party?